So there are plenty of jobs available for you with GPS. It may not be what you want, but when people bring children into this world, guess what? There is no job that is too beneath you to support your children.
He beat one charge, but lost the one that matters. Now the jury wants probation, but the real question is, will the judge agree or turn this into prison time instead?
All right, court is calling 2023 CR 2677, State of Texas versus David Joinus. Could I have parties announced for the record for the state?
Second for the state, Your Honor.
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right, are you David Joinus? Do you have any objections to this attorney standing in for Mr. Martinez? You don't have to speak up. Nobody can hear you.
No, ma'am.
All right, you were found not guilty on count one and guilty on count two. The jury asks that you be placed on community supervision. It's the court's understanding that the defense is waiving the PSI. Is that correct, defense?
That is correct, Your Honor.
Any objection from the state?
No objection, Your Honor.
All right, so I have a few questions for you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
David Joinus.
All right, I don't know why people always whisper when they come up here. I know that when people are out in the community, they're not whispering. So you're gonna have to put some bass in your voice.
I'm just scared to yell or say too much.
No, you need to speak up so the court reporter can hear. So what is your name?
David Joinus,
All right, are you employed?
not at the moment.
When's the last time you had employment?
Barely 2 months.
And what were you doing?
Car sales.
Okay. And how many children do you have?
5.
And what are their ages?
My oldest is 9, 7, 6, and then 5.
That's only 4 children.
Oh, I'm sorry. I forget my newborn. She's a year.
Okay. And if you're drug tested today, what would the results be?
Negative.
Have you ever used any type of substances in the past?
No, ma'am.
All right. Any other questions?
No, Your Honor.
No, Your Honor.
All right. So the jury is asking that his punishment be 2 years in the prison. I'm still waiting on the Joinus file. Where is the file?
Sorry, Judge. Can you finish that thought, Judge?
Hmm?
Can you finish that thought?
Yes, just 1 second. All right. So the jury assessed punishment at 2 years in the prison. So I consider I'm the person who's assigned conditions to you. So the first thing is, what length of probation time are you all asking for? Got it.
No, sorry.
What length of probation time are you all asking for?
Your Honor, the 2 years in probation is what we understood the jury to.
No, the jury is just saying that his prison sentence is 2 years, but I determined the length of probation time. So for the length of probation time, is there any requests from either side?
Your Honor, defense would request that it would be for the 2 years.
Your Honor, the state would request an upper limit of somewhere in the range of 8 years.
All right. All right, this is what the court is going to do. And count 2. Court is going to sentence you to 2 years in the prison, suspended and probated for 5 years. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And Ms. Abrams, can you let probation know I'm serious about the no employment with as a home health care provider with minors? The BIPP course. There's going to be 300 hours of community service restitution. Parenting classes. Once you complete the parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's an affirmative finding of deadly weapon. Field visits. One time per month for 3 months. There is to be no contact with Danessa Joinus, Christian Rodriguez, Charles Watterson. All right, is there any restitution to Christian Rodriguez?
No, Your Honor.
Okay. Probation. Is there anything else?
No.
All right, is there anything else you need from the court to be successful? Again, you're whispering.
Ma'am.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a jury trial, you do have a right to appeal. With regards to count 1, you have a right to have that expunged. Is there anything else?
Your Honor, at this time, defense would request that you consider the minimum supervisory fee due to his numerous dependents. And also if Your Honor would address the removal of the GPS device.
All right. What is the court cost in this case? What is the court cost in this case?
Oh, sorry. Judge, what's the case number?
It is 2023 CR 2677. Yeah, I'm good. Thank you. I'm good.
You said the court costs?
Yes.
There is no court cost on it.
No. There's going to be a court cost as to count 2. So for aggravated assault with a deadly weapon, what are the court costs?
She just got back.
All right, thank you.
Yeah, I'm sorry, Judge.
All right, the court costs are normally for this type of offense. I can't give you the specific amount, but I know it's usually assessed at about $800. Would you be able to pay that in installments?
Depends like how soon. Like.
They will set you up in installment payments.
It just depends how like how soon they can do it, because I don't have the money right now.
Okay. All right, if there's an issue with court costs, just let the court know.
Okay, understood.
All right. Now, with regards to the GPS state,
Your Honor, we of course defer to the court with the no contact order. I believe that largely covers the bases. And then just before we finish up today, Your Honor, the state would also respectfully request the affirmative finding of family violence.
all right, with regards to the affirmative finding of family violence, that would have been against the complainant in count 1. That case?
Well, Your Honor, also, I could have been
Sure.
misreading it, Your Honor, so forgive me if I.
No, if you
misunderstand.
have law that says something differently, I will consider it.
So just looking at the family code, Your Honor, I was under Title 4, Section 71.0021, A1B. In the definition of dating violence, it says because of the victim's or applicant's marriage to or dating relationship with an individual with whom the actor is or has been in a dating relationship with. So because Christian was in a relationship with Danessa, and Danessa and the defendant had a relationship, we believe that meets the statutory definition for a dating relationship, and as such, an affirmative finding of family violence would be warranted, Your Honor.
All right, I'm not going to have an affirmative finding of family violence.
Okay, thank you,
All right,
Judge.
thank you. But thank you for giving me that
I'm
section.
trying to be, I got my green tabs, Your Honor, just trying to be prepared.
Oh, no, I appreciate that. All right, now with regards to GPS, I'm going to have the GPS on for till February. Let me see. We're gonna have GPS tracking only until February 26th. State that will give you time to contact the complainant. That will give you time to let defense counsel know what areas perhaps he should not be in.
Thank you, Judge.
Your Honor, if I may, the GPS device is precisely what has impeded him from gaining employment.
Oh, no, it's tracking.
No, they won't hire me. Like, our dealerships, they won't hire me because of the GPS.
Right, so sometimes we have to look at places for employment other than what we wanted.
I've tried, they say the same thing, the ankle monitor, like even.
Oh,
like,
no, because I've seen, let me just tell you, I understand what you're saying. So for example, if I have a criminal case and I work at a hospital, they may say, Stephanie, I know you've been working at this hospital for 20 years, but as long as you have that GPS on, you can't work at the hospital. But then I'm like, but I gotta eat. I have children. You know what I do? I go get a job somewhere else. And I've seen people with GPS working at the McDonald's. And you know how I know? Because I've gone to McDonald's and I've seen them with their GPS on. So there are plenty of jobs available for you with GPS. It may not be what you want, but when people bring children into this world, guess what? There is no job that is too beneath you to support your children. Because let me just tell you why I say that. My mom had us to feed, right? And she was about to take a job working on a garbage truck. And that was back in the day when people were not putting their garbage in plastic bags. It was just being a tin trash can, and you would have to hop off the truck, pick it up, and dump it. And you know why she was going to do that? Because she had children to support. So you have 5 children to support. And guess what? You may not be able to work at a car dealership because you have GPS on. Get a job elsewhere.
I mean, like the minimum to take care of them, like jobs that are gonna pay me enough to take care of
Well,
them.
you're working and your wife's working. Your fiance is working.
Because my child support gets taken
Mhm.
off, so that's what I'm saying, I won't be able to.
Well, here's the thing, you're on tracking, right? You can get 2 jobs. And you know how I know that can be done? Because when my mom did get a job, other than working on a garbage truck, she was on rotating shifts. And you know how many hours she had to work a day? 14. And you know what rotating shift is? They have you on the morning shift. She would be on the morning shift for 7 days. Then she would get 3 days off. Then after those 3 days were off, she'd get on the middle shift. The middle shift was 3 to 11. And then after she worked 7 days for that, she'd get 3 days off. Thank you. All right, thank you. Then she would get 3 days off for that. And then she had the graveyard shift. And guess what? She didn't say, this job is beneath me, because she had to support her children. So you got to support your children. And if that means getting 2 jobs, then you get 2 jobs. That's what you're going to have to do. You understand? And when you're in this court, I require that people to have employment. And you're being on GPS till February 26th. Guess what? It's for your protection as well. You understand?
Your Honor, I do want to bring it to the court's attention that there will be a lag in the GPS. He is on GPS with pretrial. That does not transfer over to probation. He'll need to get that one removed. And then we typically give a little time for them to get another install.
How much time are you giving him for another install?
Typically, it's 10 days, Your Honor.
Your Honor, the cost of the installation of another GPS monitor, I believe, is prohibitive for him.
All right, I'm ordering GPS. So if you go to the Bexar County Jail, that's the only way for him not to have costs associated with that. And then that's going to be a whole can of worms. He would have to go into custody. They'd have to put the GPS on at custody. Then he would be released. Those are his only other options.
So he would, practically speaking, what would he do? Go get this one removed at pretrial, and then what does he get?
All right, so we're off the record. I'm going to let you all figure that out. Is there anything else with regards to his conditions?
Not at this time, Your Honor.
All right, thank you. All right, the court is calling 2023 CR 2080A, State of Texas versus Shawana Canales. Can I have parties announced for the record for the state? For the state, sorry.
Jason Garahan.
For the defense?
Robert Barron on behalf of Kelly.
All right. And are you Shawana Canales?
Yes.
Do you have any objections to Mr. Barron standing in for Ms. Green?
No.
All right, state any objections?
No.
Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Canales, I'm showing you what's entitled application for deferred adjudication, community supervision. Did you review that with your attorney? Did you understand it? Did
Yes.
you sign it?
Yes.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, we are.
Showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft, 2,500 to 30,000? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Been able to assist in her defense. I believe she understands the proceedings against her and that she's confident that.
All right, do you believe she was sane at the time of the offense?
I do.
Ms. Canales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They will take in consideration night bag number 711174. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Judge.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 140 hours community service restitution, and no contact with Clifton Smith. Did you understand that those are recommendations from the state and the court does not have to follow those?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No, ma'am.
State any evidence?
State executive number 1 with all its attachments, Your Honor. There's no objection, Your Honor.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
That's that the court followed the plea bargain.
All right, Ms. Canales, what is your relationship to Alejo Aguirre.
None, ma'am.
So why were you with him?
I know him from down the street where I was living at, and he had asked me if he could place a set of tires at the residence. So, I agreed, I went with him to go pick up. And what ended up him picking up tires, ended up him picking up a stack of some pellets, like, you know, those wood pellets.
Mhm.
And that was the reason of the arrest, because he didn't have permission to pick those pellets up.
All right, are you employed?
No, ma'am, not at the time.
When's the last time you were employed before being taken into custody?
In 2011,
All right, why have you not worked since 2011?
mental issues,
All right, what are your mental issues?
schizophrenic and bipolar.
And have you received a professional diagnosis of that?
Yes, I was on medication before in the past. I just stopped taking my medication for a while.
Are you on medication at the jail
Yes.
for the schizophrenia and bipolar?
Stabilized.
Do you have any children?
I have three,
What are their ages?
24, at 23. And then I have a 15-year-old.
All right, where's the 15-year-old?
My 15-year-old's outside the.
Okay. And I'm assuming school's not in session.
And then, I'm
They're
sorry,
enjoying summer.
and then my son is at the.
Back row judge.
Okay. So if you're released, do you have a place to stay?
Yes, ma'am.
And who would you be staying with?
With, a friend of mine,
Who is this friend?
Angel.
How long have you known this
I've
person?
known him for all my, like, since my daughter was born. He's her uncle.
Okay. All right, this is what the court is. I'm sorry, is there any questions from anyone else?
So judge.
All right, this is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication, 140 hours of community service restitution. I'm going to ask for parenting classes. Once she completes the parenting classes, the community service hours will be deemed to be satisfied.
I don't have custody of the children. But I mean, I'll still do that.
Well, I mean, your 15-year-old is here for some reason,
Oh, I'm sorry.
right?
No, yes, I'm sorry. No, I'll do the class. Though.
Okay.
I'm
Nope.
sorry.
Oh, no, there's no problem. I'd like for people to speak so I can figure out what's going on. There's to be no contact with Clifton Smith or Alejo, Alejo Aguirre. Taking consideration night mag number 711174. I'm going to want a referral to Center for Healthcare Services, regular reporting by Zoom or in person, regular UAs, and I'm going to want field visits 1 time per month until further notice. And probation, once she is with Center for Healthcare Services and they've given her case manager, then the court will consider lifting the field visits 1 time per month. All right, probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court?
The TAP evaluation, am I able to take the TAP evaluation out on the free world or?
Yeah.
Okay.
So why do you think you need the TAP evaluation?
Well, it was in.
Recommended by the state. judge.
Okay, all right, and I'm sorry, we're gonna do proof of employment with proof of employment or SSI within 45 days. And there's to be no employment as a home health care provider or with minors. And I'll allow her to do the TAP evaluation out of custody. You need to make sure you make your TAP evaluation appointment. If you don't make that appointment, then what's going to end up happening is I'm going to receive notice that you haven't made that appointment and a motion to revoke is going to be filed. Do you understand?
Yes, sir. Yes, sir.
All right, and we'll follow whatever the TAP recommendations are. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. Is there anything else you need from the court to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in both places? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you, thank you.
You're welcome. Court is going to call 2020 CR 9647, State of Texas versus Jonathan Keith Yost. Could I have parties announced for the record for the state?
Richard Get Up for the state.
Defense?
Cornelius Cox.
Are you Mr. Yost? All right. So in this case, the court was presented with a lot of exhibits, and those exhibits include these two notebooks. The court did review those once the court was made aware from both parties that this was going to be a plea that was going to be entered. Any objections to the court having reviewed the two notebooks, one being black, one being white? State?
None from the state.
Defense?
Oh, yeah.
Mr. Yost? Okay. All right, counsel, have you received all the discovery, and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Yost, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
So you're proceeding on counts 1, 2, and 2?
Yes, Your Honor.
Okay, thank you. All right, Mr. Yost, I'm going to show you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in each count, you're charged with the offense of theft over $300,000? Well, theft over $300,000 and money laundering over $300,000. Did you understand?
Yes, sir.
All right, each of those counts are first-degree felonies. The range of punishment is 5 to 99 years or life in prison with a possible fine up to $10,000. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Yost, has anyone threatened you, coerced you, or placed you in fear to get you to end this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 20 years in the prison. The state makes no recommendation for a fine. There are no applications. There's to be restitution to Dr. Ashok, A-S-H-O-K, Tholpady, T-H-O-L-P-A-D-Y, in the amount of $400,000, and there's to be no contact. Did you understand that to be the plea?
Yes.
Defense?
Sure.
State?
Yes, Your Honor.
I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Clear.
Then to count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest? Count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 in all attachments.
No objection.
All right, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in count 1 and guilty in count 2. This will come back for a PSI on August 24th. Mr. Yost, at that time, the court will make a decision on your sentencing based upon the PSI report I received back and any other evidence that's presented to me. Do you understand? Oh, it's a pre-sentence investigation report. Basically what it is, it will show me what your criminal history is. It may have statements in it from the complainant, statements maybe from yourself, and any other information about you. And then I'll base my decision upon that and also any other evidence that's presented to me. Do you understand?
Yes.
All right. And Mr. Yost, just so you know, I will receive the PSI report, but I don't review the PSI report before both the state and defense have had a chance to review it and let me know if they have any objections to it. So I'll review it after that point. All right.
If I may,
Yes.
with the with my client's bond status.
Mhm.
His bond was set very high. And the problem is that it's not that he's
Mhm.
trying to buy out. The issue is that because of the high bond,
Mhm.
he's locked down
Mhm.
23 hours.
Okay.
And we're asking the court if the court, even if the court remanded him without, then I think it will go back to general population. We just want him in general population, so he's not locked down 23 hours.
Well, that can be accomplished by one or two ways. One, if you want the court to remand him without bond, I'll remand him without bond. If both of you all would like for me to contact the sheriff's department and say, you know, what is the reason for his lockdown? Is his lockdown because of the high bond or something else? Then the court can look into that.
Okay, that'll be fine. If we can get him just in regular population, that's always
Okay.
GP.
All right. So if both parties are okay with the court asking the sheriff's department why he's in lockdown,
I'm okay with that, Your Honor.
Okay.
It's a bond.
okay. All right, so I'll talk to them today. I'll put that on my to-do list.
Thank you.
Okay,
Thank you, Your Honor.
you're welcome.
He just pleaded guilty, but the real decision hasn't even been made yet. With up to 20 years on the table and $400,000 in restitution, everything now depends on that PSI report. This is the moment where the court decides rehabilitation or a long prison sentence. Do you think the judge goes lenient here or makes an example out of him?
Court is calling 2023 CR 5724W and 2023 CR 5797W, State of Texas versus Kevin McCassley. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor. Will Brooks for the defendant, Sean McCassley.
And are you Mr. McCassley? Counsel, have you received all the discovery in each of these cause numbers and did you review it with your client?
Yes, Your Honor.
In each of the cause numbers, the court will find that the state is in compliance with discovery. And each of the cause numbers, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it? In each of the cause numbers, I'm showing you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that, those documents with your attorney? Did you understand it and did you sign them? Did you understand by signing that you're waiving your right to have a grand jury hear the evidence in this case? You're also waiving the right of your attorney, certain rights that your attorney has, namely your attorney has 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand by entering these plea bargain agreements in each of these cause numbers, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each cause number, I'm showing you what's entitled information. Did you review those with your attorney? Did you understand them?
Yes, sir.
Counsel, do you waive the reading of the information in each cause number?
We do, Judge.
State, are you proceeding on the information as presented?
Yes, Your Honor.
All right, in each cause number, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in each cause number, you're charged with the offense of theft of aluminum, bronze, copper, less than $20,000 as a habitual offender? So the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering these pleas, you were giving up those rights? Did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's my belief, Judge.
Mr. McCassley, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas? Has anyone promised you anything other than the pleas? Are you satisfied with the way you've been represented? Are you a U.S. citizen? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it? In each of the cause numbers, according to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. State recommends community supervision. The cases will run concurrently. The state will take in consideration 2022 CR 7824. NIMAC number 795249, 795252, and there's to be the anti-theft course plus restitution, if any. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, Judge.
State.
Yes, Your Honor.
In each of the cause numbers, I'm showing you the waiver of repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Motion's been overruled. I'm sorry, motion's been overruled.
Okay. Outside the agreement in each case, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, random UAs, and sober support meetings to be determined by probation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest? State in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor. I submit State's Exhibit 1 in the attachments, Judge. We've reviewed both in both cases, Judge, and we have no objections.
In each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. All right, Mr. Haslett. And each cause number to the enhancements, how do you plead, true or not true? In each of the cause numbers, after reviewing State's Exhibits 1 and attachments, the court will find you guilty and the court will find the enhancements true. based upon your plea of true and also based upon States Exhibits 1 and attachments. Are you proceeding with sentencing?
Judge, we'll waive a PSI.
All right, anything you wish to say on behalf of your client?
Your Honor, in respect to Mr. McCassley, you struggled with drugs. I've got a pretty extensive background on him from my investigator. Fortunately, he came up in a very tough home. His mother was an addict. Mental health issues, I'm sorry. That was passed today, 3 years ago.
Okay, we can't hear.
She passed 3 days, 3 years today. Surrounded her recently. I went through her patients.
Okay,
And he struggled with addiction, Judge. These are the result of the same, but in this instance, Judge, he's been in custody for 4 months. He's made a decision that he wants to change.
all right. Do you have any children, Mr. Haslett?
Yes, ma'am, I do.
And what are their ages?
A 17-year-old man, a 13 and a 3-year-olds.
And do they stay with you or no?
Ma'am,
So who do they stay with?
her mother.
Has Child Protective Services ever been in your life? And when's the last time you had employment before being arrested?
I want to say in January. That's good for me.
Okay. And have you had any type of treatment before?
Yes, ma'am, Your Honor, I also have a sponsor out there.
A sponsor?
Yes, ma'am.
Have you ever had any inpatient treatment? What type of inpatient treatment?
Excited.
All right. All right, and each cause number, this is what the court will do. Court will sentence you to 10 years in prison, suspended and probated for 10 years. There's $1,000 fine. That will be probated. This will run concurrent. Each case will run concurrently. Take in consideration night mag number 795-249, 795-252, 2022 CR 7824. Counsel, since you're in felony drug court, is his history such that felony drug court, he would pass a screening?
It may be, Judge.
Okay.
I don't know what the status is as far as numbers go. But we talked about it before. I think she's willing to get some help, certainly, Judge.
All right, we're gonna do a felony drug court and TAP evaluation in custody. Proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. CATs 1 and 2. Regular reporting by Zoom or in person. The UA hotline. Field visits. 1 time per month. Until further notice. 100 hours of community service restitution. And once you complete parenting classes, those will be deemed to be satisfied. Is there anything else with regards to sentencing from either side?
I think the state's got to dismiss and then also the TIC judge. Yes, and misdemeanors, and I'll make sure we get those set up.
All right, probation, is there anything else he needs? And each of the cause, is there anything else you need from the court? All right, and each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes.
All right, Mr. Haslett, good luck to you. We can go off the record. And this court communication is key. So if there's an issue, let probation know. If you feel as though probation is not addressing it, then just let the court know. Okay?
Thank you.
All right, good luck to you. You're gonna have to do better, okay?
Thank you, Judge.
You're welcome.
Sorry about the paperwork.
Oh, no problem. It happens. All right, I guess we'll be back tomorrow, Norma. Court is calling 2023 CR 4007A, State of Texas versus Mario Aguilar. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Robert Gear, Your Honor, for defendant Mario Aguilar, and we're ready.
All right, and are you Mario Aguilar?
Yes, Your Honor.
Counsel, you received all the discovery. Did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Aguilar, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
Yeah.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
President.
Counsel, have you had an immigration attorney speak to him?
I have not had an immigration attorney speak with him, Judge, but prior to this situation, he was already being addressed with immigration. Prior to this, he has a court date in immigration court. And from what we know, this is not going to affect what is going on in that.
All right, let's do this. Because I would feel more comfortable if he had a chance to speak to an immigration attorney concerning these charges. So, Ms. Ferguson, can you see if you can have somebody from MAC come down with regards to immigration? We'll take care of this, Mr. Aguilar, but I want to make sure that you know all of your rights. So sometimes things that you do on the criminal side, well, not sometimes, always has an effect or impact on your immigration status, all right? So, Ms. Ferguson, let's see if we can call Mac down, and then once they speak with him, we'll see how long they need for me to make a decision on this, okay?
Yes.
All right, thank you. Court is calling 2017 CR 9236, State of Texas versus Tristan Inosa. Can I have parties announced for the record for the state?
Hank Wilkins to the state, Your Honor.
Defense?
Sam Locke for Mr. Hinojosa. He's
And-
present. Your Honor.
Oh, you're on this side.
I'm sorry.
That's okay.
I told him wrong.
No problem. Are you Mr. Inosa?
Yes, Your Honor.
All right, we're here on a motion to set aside the indictment based upon failure to afford and violation of constitutional right to speedy trial. State, have you reviewed that motion?
Yes, Your Honor, I have.
All right, and are you prepared to proceed?
Yes, Your Honor.
All right, defense?
Yes, we're ready, Your Honor, and I've outlined the relevant timelines in the motion itself. And if you'd like, I can outline those. I
Yes.
believe that once I do outline those timelines, the burden would shift to the state. And I believe, and I don't want to speak for the state, but I believe they have one witness to put on.
All right. Then if you'll outline your
Yes.
reasons.
Your Honor, briefly, the timeline before the court, and it's all available to be verified on the Bexar County information system that's available to the court. This offense date was June 1st of 2012. That's 11 years and 4 months before Mr. Hinojosa was arrested on this charge. if you look at those dates that are outlined, there are two relevant dates, both of them multiple years at a time. From the offense date to the action that the state took in August of 2017, that's a 5-year delay.
Mhm.
From August of 17 until his arrest on this indictment is a 6-year and 2-month delay. And I'm not even including the 3 months between his arrest and today's date, which that's an additional 3 months. Your Honor, believe that the length of those delays taken together or even individually is so prejudicial that it affects our ability to put on a defense in this case in violation of the United States Constitution, confrontation clause and the Barker v. Wingo case, and as outlined in the motion, and also the Article 1, Section 10 of the Texas Constitution. I'm not sure what evidence the state has that can surmount those prejudicial delays, but that is the relevant timeline. Your Honor.
All right, state.
Your Honor, I have one witness and I have arguments. You want to hear from the witness first?
Yes.
Okay, Your Honor, state calls Deputy Angela Alvarado. So,
All right, if you move this way.
Oh, sure. I'm over here.
right in the middle, Judge?
Yes, thank you.
Is that okay if I'm right here, Judge?
Yes.
Okay.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Deputy Angela Alvarado.
All right. So everyone, you all need to whisper. If you can't whisper, then you need to confer outside. All right, state.
Hi, Deputy. So did you attempt to make service of a warrant in this case?
Yes, sir. It
And-
looks like on the first attempt was January 23rd of 2019.
Okay, and then did you attempt to serve that warrant on another date as well?
2 days later, sir.
Okay, and so on January 23rd, 2019, where did you go to serve the warrant?
The address I have listed here on this is going to be 3215 Fort Parker.
Okay, and did you have any interaction with anybody there?
I noted that I spoke with the uncle.
And but were you able to serve the warrant on the defendant, Mr. Hinojosa, at the time?
No, I was advised that he didn't live at that location.
Okay, and so what happened a couple days later on January 25th, 2019?
I went to a secondary address on that date. His work address at 5451 Grissom.
Okay, and were you able to serve the warrant on that date?
No, sir. I was advised that he used to work there, but quit the year before.
Okay, and did you try to serve the warrant before 2019 in 2017?
No, sir, that would not be me.
Okay, that was a different deputy.
Right.
So you were unable to serve the warrant on Tristan Hinojosa, but you attempted to serve it on January 23rd, 2019 and January 25th of 2019.
Yes, sir.
Okay, I pass the witness, Your Honor.
All right, defense.
Your activity in this case is limited to those 2 days in 2019, correct?
Correct.
Okay, there's no indication, you've got notes in front of you that you're reviewing, correct?
Right.
And there's no indication in those notes about why you came up with the 3215 Fort Parker address, is there?
No, sir.
And there's no indication in those notes of what business is at 5451 Grissom, is there?
No, sir.
Do you know what business is there?
Not off the top of my head, sir.
And there's no indication in these notes of why you thought Mr. Tristan Hinojosa was connected to 3215 Fort Parker, correct?
Not based off my notes, no.
Okay. And there's no indication in your notes of why you thought Mr. Hinojosa was connected to 5451 Grissom, is there?
No, sir.
Did you take any other action in these 11 years and 4 months between the alleged offense date and his arrest in this case?
Just beside the two dates listed on the warrant itself.
And those 2 dates were almost 2 years after the indictment, correct? A year and a half? Your 2019 attempts?
Okay, I'm not sure when.
I'm sorry, I didn't mean to interrupt you.
No, no, I'm not sure when the date of when he was arrested. Is that what your question was?
No, indicted.
Oh, indicted, I'm sorry.
Okay, you're not sure. of the
No,
date.
no, sir.
Pass the witness.
No other questions, Your Honor?
All right. Is this witness excused?
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you. Defense?
Uh,
I'm sorry, state any further questions?
I just have argument, Judge, at this.
I'm sorry, any further witnesses?
Oh, no, Your Honor.
It's Monday for me.
Yes, ma'am.
Okay. All right, then the court will hear argument. Defense, it's your motion.
Yes, Your Honor. If you look at the Barker v. Wingo factors as the courts apply them in the state of Texas, we need to look at the length of delay. I think in this case that all the parties can reasonably agree that that is a tremendously long amount of time in this case, both between the alleged offense date and the indictment, and then between the indictment and when there was any activity on behalf of the state, whatever attempts those were in 2019. And then again, between 2019 and the state's, I just say weak attempts to find Mr. Hinojosa and 2023. Any of those taken individually are presumptively prejudicial, but taken together, it highlights the exact reason that these laws are on the books, Your Honor, and it prejudices Mr. Hinojosa's ability to put on a defense. I don't believe the state's efforts to show diligence in this case rise to the level of certainly it can't overcome the negligence that's apparent from the file. And for that reason, we ask for you to grant our motion to set aside the indictment.
All right. In your motion, it states that the case was dismissed July 28, 2017, and then re-indicted the same case on August 22nd, 2017. Why was it dismissed?
From my research into the JE system, it looks like it was originally supposed to be a theft. And the statute of limitations would have run on the theft by the date that it was the case was received from law enforcement by the DA's office. It was initially dismissed as a theft, but then indicted as a misapplication of fiduciary responsibility, which is within the statute there, Judge.
Okay. All right. State.
Yes, Your Honor. So because the length of the delay was over a year, the Barker case says the court has to consider the other factors. So just a little bit more clarity on the cause of the delay. The case was indicted on August 22nd of 2017. The prohibited conduct in the indictment is from June 1st, 2012 through June 6, 2013. So it's a little bit longer because of the prohibited conduct, a little bit less of a delay rather. The defendant was a fugitive from 8/22/2017 through 10/21/2023.
Wait, I'm sorry, 8/22.
I'm sorry, yes, ma'am. 2017 when the case was indicted through 10/21/2023. We believe that's when he turned himself in once the case when he turned himself in, Judge. We heard testimony from Deputy Alvarado that BCSO tried to serve the warrant on January 23rd of 2019 and January 25th of 2019. I don't have a witness to support the previous service date that was in 2017, but I can represent the court. The notes from the MOCA system indicate that BCSO did attempt to serve the warrant in August 21st of 2017. So there were 3 different attempts to serve the warrant, Judge. The motion for speedy trial was not filed until November 30th of 2023. And the position of the state is that the defendant had not avoided service of the warrant 3 times. He would have been able to assert his right earlier. The defendant has to show that there was prejudice, Your Honor. Since it's over 4 years, the Barker case says that the court can assume there's prejudice. The state's contention is that the cause of the delay was the defendant's avoidance of the warrant. So I think the type of delay that the defense is claiming here is that their defense is impaired by this delay. But if the cause of the delay was the defendant's avoidance of the service, I think you shouldn't reward that, Your Honor. And There's a case, Dragoo v. State, which is a CCA case from 2003. And the holding in that is that the defendant acquiesced in the delay by avoiding service to the subpoena judge. So that's the state's intention, Your Honor.
All
I
right.
see that you denied a motion.
All right, and defense, it's your motion, so I'll give you a final argument.
Well, just briefly, Your Honor, there's no evidence before the court that he avoided anything. There's no evidence before the court on reference to a 2017 attempt to serve a warrant according to notes. And I've just, as an officer of the court, and I've spoken to Mr. Wilkins, he and I discussed that entry. And that entry into their MOCA system, as he described it, is problematic. So I'd ask the court not to consider that. And again, Your Honor, I think the characterization that he's avoided service is inaccurate.
All right. And then the dates where they're saying he's a fugitive. I know sometimes people say fugitive, but nobody knows that there's a pending case. So for the dates, August 22nd, 2017 through October 21st, 2018, state when you said he was a fugitive, is that just a matter of there is a case in existence? Either he knows about it or he doesn't know about it, thus he's a fugitive?
Yes, ma'am.
Okay. All right. Is there anything else from either side?
No, ma'am.
No, Your Honor.
All right. So if you all will be back at 10:30, I'll let you know what my decision is.
Thank you, sir.
Thank you.
And that's what makes this hearing so tense. Both sides are telling two completely different stories about the delay. The defense says the case got stale and unfair. The state says he avoided service and caused the delay himself. Now the judge has to decide whether this case moves forward or gets thrown out entirely.